Good. My favorite voice. Good morning, everybody, and welcome to continuing professional education hot topic for the month of, I guess we are in April. And I'm going to mute all of you real quick. I am Phil Brilliant from Continuing Professional Education Services, and just a couple of ground rules as we go through on how we'll do this morning on our hot topic of dirty dirt. We were all just talking that all these years later, we are still talking about dirty dirt, but we are. And even months after doing this back in June, we are talking about new information and new angles of dirty dirt. With me this morning is Julianne Masago, Director of Operations from Continuing Professional Education Services, CPES. And we have some great guest speakers that are really going to lay out and make sure that we know exactly where we are at DEP when it comes to the A901 or where we are not. And we'll get a little bit of both this morning. Some, few ground rules. If you could continue to keep yourself muted, I will do my best to keep you muted. It just allows people to speak and the background noise not to be overcoming their voice. Also, we are recording this. This will go up on our website at CIANJ.com. If anybody would like to see it, share it, or review it so you can make sure you get all of that great information you may have missed this morning in your notes. If you have questions, a couple ways. One, I will monitor the chat. You can put your questions into the chat. We'll make sure we get all of the questions answered this morning. And if there are not answers to your questions, we will do our best to try to find those answers, because as you will hear, there is still some lack of clarity in where we stand today with A901. If you raise your hand, I can also, you can unmute yourself. You can ask your question directly. We're going to go through a presentation this morning, which will probably take about 20 minutes, if not a little more. And then we're really going to open it up for Q&A, because we do know there's still a lot of questions out there when it comes to the A901. Julianne, did I cover everything? Good. So without further ado, I'm going to introduce, we have three great, I'll call them panelists, even though they're all over my screen this morning. So in no particular order, the gentleman who said there's how many, 7, or I already forgot, Tony Russo's in Jackson Township, New Jersey. But Tony Russo is the President of Commerce and Industry of New Jersey, the publisher and CEO of Commerce Magazine. I always like to give something a little interesting. In his past life, he has been an environmental consultant, as well as a regulator at DEP, and has a degree in mechanical engineering from NJDEP. So not your standard statewide business organization leader. Tony kind of touches a little bit of everything. Tracy Straka, Executive Vice President of Kramer Environmental, founder and chairperson of the Environmental Business Council of CIANJ. And I did some research. So holds a bachelor's from George Washington University in biology and was on the pre-med track. We're going to have to dig into that. You've gotten as far from pre-med as you could possibly get. But
I dropped out of medical school to be a rock star, and the rocks turned out to be in the ground and not in the guitar.
I like that. And then Jennifer Solewski. I always pronounce that wrong though, Jen, I apologize. Vice President and Business to Technical Development of Bayshore Recycling Corp. And she too holds a degree, engineering degree, environmental engineering from Stevens Institute of Technology, and was a member of the fencing team.
Come on.
These little known secrets about everybody. But, hey, if you put it on the internet, I'm going to find it. So glad everybody could join us this morning. When we did our prep yesterday, we really didn't say who was going to kick off first. So I will open it up to the three of you right now to see who wants to talk over who.
I'll kind of start just a little bit because I did the first part of this. I believe most of you that are joining for this update were on the original phone call where we kind of went through the rule, what applied, what didn't, and I think we left with more questions than answers. Since then, I guess we are on our third round of FAQs, actually 2 since June that the department has published. And I think we're going to spend some of our time going through the FAQs, not to read them, but to discuss the relief that we got and then the new questions and cans of worms that it kind of opened up for us. And then both Jen and I have been working with Tony and Commerce and a whole group of different industries, working with both Senator Smith, the DEP, and the AG's office to further try and get some clarity and tightening up of what's really supposed to be included and what's not. So I'm sure Tony will jump in and speak about that as well. So I think, Jen, do you want to start with the FAQs? And we can kind of do this as a dialogue. We don't have prepared slides this time because it's mostly a discussion of things that have come up as we've gone through the FAQs. And then I think we're going to share a little bit, at least, about what I'm envisioning planning for our particular company till we get some of the additional clarity, and Jen can talk about what she's seeing in some of hers, and Tony can share what some of our members are doing.
Yeah, great. Good morning, everybody. So before we jump into the FAQs, just a quick timeline of where we are as far as the DEP stakeholder process and how everything's kind of unfolding. So the DEP started their stakeholder process and they had their first meeting in December, and then their second meeting in, March 1st. So the first meeting was long and more productive. The second meeting, not as productive, focusing on, what the group was considering a broker, not really a lot of guidance on where they were going, and not really a lot of questions as far as, what's working, what's not working. Then they put out the next compliance advisory that had the most recent FAQs. That was put out, I guess, March 22nd. Is that right? I have too much paper in front of me. And then, and so the compliance advisory, attaches the FAQs and the new certification for non-restricted soil and fill recyclable materials, which is, a big thing we're going to talk about today. So I guess the FAQs that came out. Oh, sorry, it's March 16th. I don't know where I got the 22nd from. My apologies. So the first thing that addresses was the extension to the registration. So registration for those of you or your clients or whomever who are may be applicable has been reopened. So now we have until July 14th, 2022. Then that date is also mirrored by the last day that you can actually submit your 901 application. We'll go into like what we're asking for later. Tony, what do you think? Yeah. Okay.
Yeah.
So that's where we are with the registration. So the registration form is back up in the 901 forms on DEP's website, and I think Phil just shared the link to those. Then they had the definitions of soil and fill, recycling, are still the same. Nothing's changed there. It talks about what soil and fill recycling registration allows your company to do. And they differentiate. They do still go with the premise that the soil and fill registration is not doesn't allow you to operate as a full 901, so it's still outside of solid waste. But a lot of the confusion stems from the fact that the 901 rules and the solid waste rules and the soil and fill is all wrapped up into the same law. So yeah. So I guess we want to focus mostly on right now the question 6 with the new clean, like the whole non-restricted soil and fill definition. So DEP has now added a certification that's about 4 pages long, where
they actually created a new category
correct
of
yes.
materials that has not existed before.
Right. So,
and then developed an entire certification process around this new category of
And
materials.
right.
I guess Tracy and Jen, if I could just jump in just to give
Sure.
some context, how do we get to the second revised FAQs? It was kind of interesting, and just for, you know, for historical purposes. I mean, I remember being at the State House when the bill was introduced. I listened to the SCI report being presented to the legislature, and it was interesting that when the law was signed in 2019, that, you know, a lot of things happen rather quickly in Trenton, as you all know. I mean, the bills go through sometimes without really thinking about the unintended consequences here. I think the things that really created a lot of consternation for a lot of folks, and I'm sure many of you on the call, was the definitions of broker, consultant, and salesperson, right? So park that for a second. Though the other thing that really nobody appreciated during the actual legislative process was we were going after dirty dirt, but the statute really never defined what dirty was. So what ended up happening is when the law was finalized, then the pandemic hit, and then everything was pretty much shelved for 2 years. So, you know, you lose that historical, or the just, you forget, well, okay, what was the context? What was the intent? So now you fast forward now, you know, the registration process opened. Now you have a lot of people calling me and other trade groups saying, wait a minute, you know, do I need to register? I move soil. Well, I'm not sure if it's dirty or not. And, you know, I think, and I want to give the department some credit here, that after, I guess the first stakeholder meeting was in December, but prior to that, when the registration came out, I remember talking to the department, I said, geez, you know, we're getting a lot of people asking questions as maybe they touch a soil pile that they need to register and apply for the A901. So it kind of evolved. And to Jen's point, if you look at the FAQs, question 6, the department since December until March, they actually were trying to figure out a way where, you know, people can self-certify that the material is unrestricted. And I want to be careful. It's unrestricted or non-restricted, right, Jen? Non-restricted?
Non-restricted soil or fill, yeah.
Right, where the department is basically saying, well, if you want to self-certify that you handle non-restricted, then you don't have to get the license. But if you look at the certification application, it basically says you may have to prove that someday in case you ever get questions. So we actually had a couple of calls and people were basically saying, well, wait a minute, you know, anybody that's a good actor is going to sample that soil pile to make sure that it's not dirty. So there's still a lot of issues that are unresolved that we should talk about today, because I still do believe that we're going to need a legislative fix to resolve a lot of these issues. And I could talk about the time frame, but I'll kind of park it there and I'll send it back to Jen and Tracy. But so again, that's the one issue, is looking at that self-certification. Does it really help, you know, take a lot of folks out, or does it really complicate matters now? Because you now have to sample your soil pile that you maybe didn't do it before. And
Right.
again,
Well, you don't actually have to, according to this, just for your own liability, and owners may want it, attorneys are going to counsel you to do it. There's not actually a sampling requirement, nor is there a definition of, if you sample, what do you have to do? It's just kind of implying that you're going to have a whole lot of liability. And this is one of the big gray areas where it was a good first step towards trying to get some people out, but we need a whole lot of additional clarity going forward to figure out with this non-restricted fill and recyclable, if there's a problem down the road, is it just going to be kicking a can down the road? Is there going to be some sort of better guidance or criteria to support question 6, and I guess also question 7 on this FAQ? Or is it going to be the Wild West of, we're going to sign these certifications and some people are going to be really, really conservative and others aren't going to care?
right.
Yeah, so the most interesting part of the non-restricted soil and fill recyclable material certification is the way that non-restricted soil and fill recyclable material is defined. It almost mirrors the definition in the law of soil and fill recyclable materials. So, I mean, verbatim, it's incredible. So it seems, you know, that the DEP is struggling with whether or not to regulate clean fill. So if they define non-restricted, we used to have unrestricted, whatever, 20 years ago or so. Now we're looking at non-restricted. So they're not defining clean fill, but they're defining what's non-restricted, meaning non-regulated materials. So, but like Tracy was saying before, it's up to the certifier to have the backup to prove whether or not that material is non-restricted and doesn't fall into solid waste or the 901. So, where it says that that the non-restricted soil and fill, it's excluded from the definition of solid waste under the solid waste rules, is the same exact material that they're trying to regulate under this 901. So, without proving that it's clean and without having set parameters, or say non-restricted, right, uncontaminated, to have, it says that it can't, it can't exceed the criteria, but without set sampling frequencies,
or any guidance at all.
Are we proving on waste class, which are composites, or are we proving on discrete samples in accordance with SRP? There's a lot of open-ended questions there, but I think that is the intent of the DEP, not to, to leave it up to the certifier, just based on what we're seeing here. It does take a lot of people out. If you are doing land clearing and there's no known sources, things like that, and you want to move the material, for applications like that, the pool contractors, that we talk about all the time, this won't take away landscapers or things of that nature, because the FAQs go further into the de minimis quantities, and they're still hanging on the 15 cubic yards of non-restricted fill as their, as their threshold, which does coincide with the Guard Your Yard model ordinance that was posted.
Right. And as we all know, that's not a lot of material.
Right.
And then the other, as I was thinking more about this last night, it dawned on me, the DEP has not backed off the layering of needing to have a 901 to hire a 901. If you're claiming that you're working with only non-restricted soil and fill materials and you wind up with one bad load, do you now have to go get a 901 to go hire somebody to deal with that one bad load?
Right. Yeah. Yeah, we talked about that. There's no clarity. If you do go to prove that you're only dealing with non-restricted, I can't anymore.
Yeah.
Non-restricted is if you go to prove that, and then you do get a sample that comes back that exceeds non-res or one of the residential criteria, and then you have to manage it in accordance with the 901 for soil and fill. Or a solid, if you manage a solid waste, you can hire a 901 in accordance with the solid waste rules. But the way that the FAQs are interpreting the DEP's interpretation of the law, they don't break out the ability to do the layering. So if you took this sample, you're captured under this giant cast net at this point. So we're trying to streamline that and just, either you hire a 901 or the 901 is applicable to the entity that has control over where the material is going. So, I might be a professional and I have analysis here that, and based on my knowledge in the industry, I have XYZ facilities that this meets, and I present that to my client. At this point, I'm roped in, whereas I'm not making the final decision as to where the material is going. If it's going to a class B, great, you're exempt and you don't have to worry about it. If you're going to a BUD site or an SRP site where there's LSRP is reviewing the data that you're presenting versus the fill protocol in their site, that's also exempt. So it's all, but if you wanted to go to a landfill or a mine reclamation in Pennsylvania and you don't have a BUD, then that's where you're falling into it. If you have another fill, I guess, site that you have, that you want to bring the material to, that's where you're going to fall into the caveats of this.
Can I pose a question to you guys?
Sure.
What I thought was a simple answer, and it's not so simple. So, Jen just touched a little bit upon it. If you are an LSRP,
Yep.
you are quote unquote exempt from the A901 if
If.
you are doing remediation, okay? But
Yeah.
if we look at everything that's outlined in A901, that appears to be a company. So, LSRPs are individuals.
Correct.
So is an LSRP always exempt?
No.
And as an A901, is it the company or how does all that play out and interact with an LSRP? I know there's a lot of LSRPs and contractors, and this has been the biggest question. How do you pierce out the difference, and how do you make the decision? I know Tracy and Jen, maybe you can give your personal on if the company needs to go for the A901 and who needs to go.
If an LSR, there was some clarity that was put out actually just about a year ago, talking about when an LSRP is or is not in. Some of the FAQs contradicted or muddy it a little bit, but my understanding, and this is, I guess, kind of the rub, is DEP says if you're an LSRP, you're always an LSRP, and that's kind of their, your hat is always on. But then in this document and some of the follow-up discussions, you need to be the LSRP responsible for the remediation of that site. You just can't be an LSRP that's a broker. So if that license doesn't entitle you to just become a broker, you need to be the LSRP doing a site remediation, having direct responsibility for hiring it. If one of the people that's working under you is coordinating all that disposal, I don't believe they get that exemption.
So in that scenario, the person who's working below you either needs to be A901 or work for a company that's A901?
Correct. Or the LSRP just makes the phone call themselves.
Right. Tracy, how's your company handling this?
It's interesting because we just had a very long discussion. We're not LSRPs, we're contractors. And, we had a previous discussion years ago with the AG's office for both the solid and hazardous waste based on the burnt fly bog decision. And we gave up our 901 because we're not strictly brokers. We're only moving material in accordance with other work in the contract. And that gave us very clear, at least according to the AG's office, reason that we didn't need a 901. And it was fine up until this happened. Now, we're actually redefining on paper, if this layering issue doesn't go away, that we're going to have an internal management process so that only very senior people can make the T&D decisions and get everybody else out of a management role because of the personal disclosure, because I will have employees that will quit because they're a project manager or a project engineer and they're picking up the phone and making the phone call to have a truck go or filling out the profile for waste disposal. And I don't need to put them all through the background disclosure. And then I know when we don't pay them enough to do that. And a lot of them have already said that they're going to just leave. There's other jobs that they don't need to do that. And that's a real big issue on the personnel side. So we're going to have a whole different process in place, and we're going to, the senior people are going to be doing some of what we would consider entry-level work to make those decisions and do all of that coordination. So it's going to suddenly become an officer and director level decision for T&D in this company, unless we can get the layering exemption.
And we did look at how to propose the layering exemption, especially for this audience specifically. It's the most applicable exemption that would benefit this group, because if you're doing due diligence, if you're somehow touching this project, the way that the definitions of broker, consultant, et cetera, are laid out, you know, it's just too big of a cast net. So so what we propose is just to, you know, make it a registration. So leave, if, you know, we're all involved in soil and fill, fantastic. So we register. There's no denying or hiding that we're doing this activity, but to fill out the full 901 application when, you know, we're not the decision makers on where the material's going, if it's going to a spot that's outside of what's exempt here, then, you know, then this way, you know, you're in it, the department knows this is what your business dealings are. And then, you know, an annual report, say, with where the projects are, what you worked on, where you took the material, and then, you know, then they can connect the dots with who had the A901, et cetera.
Yeah, there's several trade groups that are making that same ask. There's no commitment that we're going to get it at this point. I think DEP liked it. I think Senator Smith's office liked it as a nice compromise. It makes everybody's life easier. And the real goal is they want to track where the dirt's going, you know, whether it's, you know, the new sales guy that I just hired out of college, or whether it's, you know, somebody's brother-in-law that's not in the mob, but just happens to work here because a family member, you know, needed a job. That shouldn't matter. The goal is we're trying to keep bad dirt out of places that it shouldn't go. So as long as the DEP, you know, knows where that dirt went, who transported it, and who disposed of it, and how much went there, I think everything else is irrelevant personally.
Yeah, I think, and you hit it right on the head. I mean, that's why, you know, if you look, Phil, at some of the comments that are coming in just the past few months, you can't really predict every scenario that's out there, right, in the real world. I mean, whether you're dealing with landscapers, pool operators, you know, LSRPs, non-LSRPs. So, you know, the Tracy and Jen's point, let's maybe the solution here is, and by the way, if we wait, you know, for the DEP process to play out, I mean, they acknowledge that the rules may not come out for another year, but yet the application deadline is July 14th. You know, so what do we do in the interim? So I think a good solution would be, like they said, let everybody register. I don't think anybody would complain about that, but then maybe wait and figure out who really needs the A901 based on some clarity that we could provide in the law, right? Whether we exclude certain people, whether we raise the minimum thresholds, you know, we could play out those scenarios.
Yeah, you know, even the DEP, but they didn't, you know, they tried with their Q&As, but in question 19, they talk about which salespeople are involved, and then in question 22, it pretty much says all salespeople. So, you know, if somebody's selling a job and T&D happens to be as part of the job, are they in or are they out? And the two questions give you very different answers.
So Tony, you threw a couple things out there. One of the questions that just came in, and I think we've kind of answered it, but it, you know, it's that gray area. You know, if I'm installing wells and have IDW, so I'm always trying to figure out IDW. I should know this one.
Investigation derived waste.
Derived waste. Thank you. Thank you, Rohan. And dispose, and it turns out there's no discharge and everything's clean. I'm not an LSRP of record, therefore I don't enjoy the exemption. Is this correct? And then goes on to say, or is the investigation fall under the larger definition of remediation? And that gives me the exemption. And this is this, again, we can go back 20 years on what's the definition of remediation.
Well, it still goes back to what's in the investigation derived waste, where you're taking it to, and whether you're the actual LSRP in charge of the remediation for that site, or if you're doing it for due diligence. So there's 3 or 4 different answers, depending on what you're doing and what's in the material and where it's going, that can change how we're going to answer that question.
Jeff asked, did I hear before that as currently written, someone working at the same firm for an LSRP, i.e. a project manager, non-LSRP, cannot arrange for soil management / disposal, that the LSRP actually needs to be making the call?
If you want that exemption, that's how I read it. I don't know if the department's interpreting it the same way, because where was the?
Okay, but I guess.
Or subsurface evaluator, they get that same exemption.
I guess this is what I guess I'm concerned about is, you know, all these questions are gonna pop up. Am I in, am I out? And that's what I've been trying to tell the DEP and also the legislative staff, that we need some clarity in the legislation. You know, who do you really want to go after? And that's why I'll go back to, if everybody agrees, and maybe this is a play here, is that we pursue that everybody registers. So every, you know, engineering company, consultant company registers. Yeah, I'm in the business of, you know, moving soil and disposing of it in one way, shape, or form. Maybe I'm on the consultant side, but, you know, my company's registered, but I don't need the A901, because we keep going back to, you look at who's going to haul the dirt and where is it going to go, right? They're just trying to make sure that the bad stuff stays out where it shouldn't be. So to me, that's why we need some clarity in the law and not wait till the regulations come out, because I don't know if a lot of these scenarios are going to be captured. I don't think you want the department, and I don't know if they have the resources to be answering phone calls all the time. You know, am I subject or am I not subject? And that's why I think, you know, programs like this, Phil, are important. You know, and by the way, the coalition includes UTCA, the Builders Association, BIA, the State Chamber, you know, the
Utilities,
the landscape contractors, because everybody is asking the same kind of questions. Am I in or am I out? And I don't know if we really have the time to work it out in regulation. And that's why I think we have to go in for a legislative fix.
I just want to say, I just want to ask a question on, so Tony, did you just say that you think, and I don't want to put words in your mouth, everybody should just go register?
No, that's I think what we're going to offer up as a solution here. That's easy, right? So, you know, and the registration process is open. So now if you just register your company saying I'm in the soil business somehow, you know, I touch, you know, but not do anything else until we could kind of figure out, you know, who really should apply for the A901. Maybe that's a solution, and that's could be an easy legislative fix to say, open up the registration, keep it open, right? Let people, you know, register. But in terms of the A901, work with the stakeholders, work with the DEP, work with the legislature, and figure out who do you really want to get the A901, right? And they're probably going to realize that a lot of the people that, you know, are actually hauling the soil and disposing of it probably already have an A901.
Right.
In the scenario you brought up in a couple of calls ago, you said that somebody had registered and applied and already got a $12,000 bill from the department.
No, it was $21,000.
$1,000 bill to review and they hadn't even reviewed the application.
Right.
Okay. So if I register, I'm not getting that bill.
No. They actually applied for the A901 on advice of counsel. So they actually missed the registration period, but now that it was back open, they were okay. So they said, look, let me just apply for the A901. And they did that, and they got a bill for $21,000. They pretty much didn't pay it because they fell in that category whether or not they were going to be subject to the rule and to the requirements. Because what they did was, you know, it was a farm that collected some soil, put it in those plastic pouches to resell to consumers. So the question was, how much soil did they bring in? Was there any sampling? Where does it go? And, you know, if you look at the FAQs, they try to exempt some of those situations. But again, it wasn't clear, right? I mean, you know, and that's the consternation that has been caused is, you know, and again, Phil, when you think about who we represent, I mean, we got landscapers that call me, you know, we have contractors. And by the way, we have property managers, right? This came up this time, that manage properties that are abandoned or vacant, and they call up a waste company like Waste Management to come. Well, the DEP is saying that maybe they're a broker, and maybe they're subject to the A901. So this, you know, and that's why it's important to try to clarify a lot of these issues, because I mean it's complicated and it's scattered. My concern though is I just don't think, you know, waiting for a year really makes a lot of sense.
Well, and to that point, Tony, we have, like, you know, the time that it takes the AG's office to process an I-901 application is incredible. Some people wait a year, 2 years. It takes a very, very long time. And that's with a limited amount of applicants. So now if the DEP and the AG's office just looks at the number of registrants alone, you know, and say that they don't offer like the layering reprieve, and all these entities will have to register for a full 901. They'll be inundated. I mean, they won't be able to get through it, and then they won't be able to prioritize like who's actually applicable, because they won't give the you know, the clarity on applicability. They say, oh well, you can register, and then if you decide that you're not applicable, you should seek advice from your attorney, which is,
Yeah.
you know,
And by the way, I want to give the department, the Division of Law, and also the Senator's Office and the Office of Legislative Services, because I think they were well aware of these issues, and that's why we were fortunate to get the extension, you know, to July. But I'm not sure that we're going to get a lot of these issues resolved before July, and that's the issue. And hopefully we can work with them on either getting another extension or getting a legislative fix, which isn't going to be easy. And, you know, it's something that unfortunately we're going to have to pursue
Right.
as we work with the stakeholder process and try to clarify a lot of these issues. But I keep going back to what I said. I think if we address the broker, consultant, salesperson issue, if we maybe try to define what dirty is, and I know that opens up Pandora's box, what's
Right.
clean, and they avoided the word clean, and they went with non-restricted. You know, you just don't want to put that landscaper that maybe deals with another landscaper, goes out to the site, digs up some dirt, it's above the thresholds. Now, you know, he or she need to be licensed. And, you know, if the fallback is let them all register so the department is aware of who they are. And if they have to, you know, track down some dirt eventually, then that's a good solution. And then worry about the A901 later, you know, who really needs to Jen's point, it takes 12 months, 18 months to get the A901, and it's
If you're
complicated.
lucky.
Yeah.
And, you know, they haven't even addressed things. They actually made it a little bit more stringent since we've done it with more people involved and lowered down staff levels that are included in this background check. So if they have, you know, companies that are ESOP, they may have, you know, 50 or 60 owners. You know, some of the, you know, bigger firms have hundreds of owners all over the country, all over the world. It's not limited to just New Jersey employees.
Right. And by the way, if we don't get anything between now and July, at least, again, the self-certification, you got to look at the application. And it's all about risk, right? What kind of risk are you willing to take if you don't want to sample? And you want to say, oh, I'm pretty sure that this was clean, you know, or I should say non-restricted. Then you can certify that, you know, you're exempt and have that on record. I think there's requirements to keep the records for 3 years. Then you don't need to apply for the A901.
Two questions, and I'll ask hopefully the simple one first. So if you're an LSRP and you're dealing with remediation, okay,
Yep.
cleaning a site up, you know, what we all believe to be the definition of remediation, okay? If you're handling all that, chances are you don't need an A901. As long as you are intimately involved, you haven't delegated any of that responsibility, you know, you're good, okay? You know, I'm going to kind of twist what Rohan asked here and just make sure. So if you're not actually moving soil, directing the moving of soil, maybe you're just, you know, in his scenario, his question was providing a bid package or doing municipal type work and soliciting costs. You know, you're averaging out how much soil is going to be removed from this project. So you're involved, but you're not actively moving.
Are you an LSRP or not? Because
not.
otherwise you got to go look, you got to go read that definition of consultant.
but I think that municipalities are exempt.
Well, yeah, the
So
municipalities themselves are exempt, but their
Themselves.
consultants, I don't know that they are.
Right.
That's not clear one way or the other. If it
That's
was
right.
not a municipality doing the exact same thing, that consultant definition absolutely applies.
So municipality has a consulting engineer that does all their work. They're not, you know, the municipality, they're an outside contractor.
I don't know the answer to that. I don't know if nowhere does it say that the exemption applies to the people that you hire.
Right,
What a
but I would
possibility
I would
to-
argue that it does, because, you know, you're doing the work for the municipality. The municipality is eventually the ones that are putting it out, the bid out, everything's coming back to them. You're, as the consultant, you're reviewing it, but I don't know, I would argue that it would be
That's
exempt.
the answer I would,
for-
yeah, that's the answer I would like to see, but it's not
Yeah.
clear.
We hope everybody thinks like you, Jen.
Yeah.
You know, that would be the best, but it's another one of those gray areas. You know, we talked yesterday as we were prepping for this, as I was watching the property behind me get filled in by the pool company who was dumping load after load after load. You know, they're not exempt either. These pool companies, right? Especially
No.
the 15 cubic yard
15
threshold.
cubic yards is a little tiny pool.
Yeah, that's a small hot tub. So, you know, there's a lot of potential soil movement. And I think, you know, Tony, your comment of everybody should possibly register, that's another group that probably needs to be involved and register, you know. But again, I mean, you know, pool companies, I mean, they're going to go through the entire A901 process. You know,
No.
they don't have LSRPs on staff.
No,
They're
and
not
that-
getting involved in remediation.
Yeah, I want to be clear, Phil. I think the registration is one thing. And that's a position that we could take just to kind of assuage their concern that they don't know where these soil piles are going, right? You know, so if people register, at least they've been identified. I'll have to go back through my notes, but I'm not sure if there's a registration fee or not. But, you know, that's one thing, and then park that. And then we can continue this discussion and kind of filter out, you know, scenarios where, again, you know, who really should have the A901. And I go back to, hopefully they get to the point where they fall back to whoever's transporting the soil and wherever the ultimate facility is, just make sure that they're licensed. You know, this term about broker, sales consultant, or salesperson consultant, again, it opens up so many different scenarios that we just laid out here, a few, and there's really not a lot of clarity yet. You know, and we could wait and maybe they get clarified in the rule, but you know, in real time, people need to have these answers now before July, you know, before they have to apply, you know, but.
I'm gonna ask a question, then I have a question. So this goes back to Tracy, what you just said. If you do the same service, just a bid package for a private client, and you're a consulting engineer, but not an LSRP, you then need an A901?
I could read this to say that falls into the category of a consultant that has to register because they're getting paid for it.
Yeah, I agree. I agree. At this point, based on the DEP's FAQs, if you're making recommendations as to where the
Yep.
material is supposed to go, and they're outside of the exemption. So if it's not, you know, if you're saying you can take this material and use it, you know, in a way that's outside of going to a licensed facility such as landfill cover, Class B bud site, you know, then if you're making recommendations outside of the exempt facilities, then you would fall under A901.
Going back earlier, I'm actually just rereading question 16 about the LSRP question and the people working under them. It reads that it should be noted that if another person is subcontracted to procure contaminated soil for or remove contaminated soil from a remediation site, including a person employed by the same company as the LSRP or SSE, that person is required to file for a 901 or file the PhD if they think they can get that exemption. So they actually do answer that in question 16.
Okay, I'll take my deep breath.
Not the answer you wanted to hear, I know. Not the answer.
No, and I think, you know, it's interesting. So they lump LSRP and subsurface evaluator together.
Mhm.
Subsurface evaluator is a minute service on
Correct.
one aspect, home heating oil tanks.
Mhm.
Okay. LSRP is, you know, 14,000 sites in New Jersey, 650 LSRPs, you know, doing things, and, you know, we're not going to argue the due diligence definition and whether that's remediation or not, but that's a huge issue that comes out there. But, you know, if you're an LSRP, basically what that means, Tracy, is you're not delegating any of your work unless that person is an A901.
Yep.
That's not the way the program was written.
Correct.
That was not the intent.
Right, well, due diligence is, yeah, that's
Yeah.
totally out. It's not a site mediation unless you're calling it a site mediation project, but depending on who you're doing the due diligence for.
What you're asking. That's another day. That's another argument for another day.
Yeah,
But so Tony, and Jen and Tracy, I mean, we have 15 minutes left here.
okay,
If we can give the best guidance possible as to what people who are LSRPs, contractors and others, and then is there, in your mind, an easy fix coming by that July date? Or are we punting and just going to sit back and wait to see where the department takes us?
we are not sitting back. That's the easy part. I guess my personal recommendation is I would tell everybody that may fall into this to fill out the registration, because that's a easy lift, and right now, no cost associated with that initial submitting of the form. It's letting the DEP know you exist. And that buys us a couple of months. My second ask is get involved with an association, grassroots movement. It was suggested at the last meeting. Make phone calls, write letters. Let's see if we can get it fixed, or hopefully at least the 901 portion of this requirement, like Tony said, it's going to need a legislative fix pushed out till there's rules, so that we actually understand, it's not an easy lift to A, complete the process, B, it's expensive to hire the consultants and attorneys to advise you. And then when you're going to get a $20,000 plus bill from the DEP before they've even looked at it just for submitting it, and you don't even know if you're in it, that's kind of a really heavy ask on the DEP side.
By the way,
And then-
play out the scenario. What value does the state of New Jersey get if we have a consultant out there, LSRP or not, that maybe, coordinates the pickup and disposal of soil 5 to 10 times a year? And now he or she has to apply for an A901, which is so cumbersome, to say, yes, I'm not a criminal. I don't have I'm not a bad actor. Let me continue doing my job. So this goes back to the classic argument, is the intent here to regulate the material of the individuals, right? And I think everybody would probably argue back that it's probably both, right? But there's no clarity. I think we've just learned in the 7 months or 8 months that more scenarios pop up than anyone ever expected.
Right, but the reality, and it's New Jersey, there's whether somebody's cousin's brother-in-law is tied to organized crime and owns the company, if they're not dumping it illegally, there's so many big businesses now and there's so few places to take it. Those bad guys already have the 901s because they've got somebody fronting for them.
Yeah.
This is, the rest of the people, they're looking to catch the little guys. Does it really matter who their family is? There's dirt going from point A to point B. It's either going to a facility that's exempt or a facility that the DEP is going to know about.
Yeah, so I'm looking at some of the questions in here. I mean, that's what I was going to say. I mean, everybody should register, right? If you needed to register, the
Yeah,
registration
that's my
process-
opinion.
So even if, and this is an important thing, even if your registration came in after that October date and you were denied, the department wants you to re-register. So I would go ahead and do that. And then, yeah, wait. I mean, you have until July 14th now to apply for an A901. Let's just wait to see if we can't get some of these issues clarified. Because again, I mean, there's really no reason to get it in sooner unless I'm missing something, but I would.
No, but actually, somebody did make a point that if you already registered the end date, did we get a tacit extension of the original expiration date to the new due date? I guess we should
It's not
officially
clear. We
ask
should
that
find
question.
out. Yeah.
Good luck, Tracy. Everything has been extended to July 14th.
Right, including, so if we have applied and your expiration date is April 15th, do you automatically get till July or do you have to ask again?
Well, I don't understand what that means, that they
If-
applied already?
Right, if you submitted your application when you were supposed to, it was good for a year
Yeah,
till you applied, and then they extended the application date 3 months. Do we automatically get that 3 months or do we have to ask for it?
for that specific application. No, I think it's.
For all of our applications, all the people that got them in early, or, it was originally April 15th to April 15th.
Right, I think they're extended, sure.
Okay, we never actually officially asked that question. I think they should be, but
Yeah, I mean, honestly, I don't know if the department, I could be wrong, but I'd be curious if the department has processed any applications and approved anything, while we're working these issues out.
Yep.
I don't- But again, I'll be curious, Phil, to ask everybody on the call, is anybody concerned or opposed if we went let's all register, keep the registration process open indefinitely? Maybe
Yep.
the legislative fix this, to Tracy's point, the amendment can say, everybody should register if you're involved in soil operations. And then A901 gets pushed out, until the rules come out, or we can try to clarify some of these issues in legislation. Because one of the approaches we were going to take, and I'll be more than happy to share what we submitted last year for legislative amendments. And according to the Office of Legislative Services, there wasn't a lot of pushback as to what we wanted. It is maybe, keep it simple here and just maybe put an amendment in that excludes certain operations, certain entities. Because I mean, we haven't talked about the utilities here, still have some issues. So I know the NJUA is working on that. The landscapers have a lot of scenarios that they need clarity on. So maybe go in with an exclusion and say the following entities are excluded. Might make it easier. I'm just not sure if the department is willing to do that.
And Tony, just to be clear, if you register, what are your obligations?
Well,
Nothing right now.
There are none yet
There are
because there's no rules
None.
out.
Right.
The DEP's
the
comments on the
application
FAQs.
can continue to operate. I think it actually says in there, you can continue to operate
Right.
until you get the application in now by July 14th.
Right. Tony,
without
it
the
might be
rules,
helpful
Go ahead.
if you post, I don't know how many people are on LinkedIn or send to Phil, the asks that we've already made so that people who are involved in other organizations or who want to write individual letters can hopefully make the same asks. Can we arrange to do that somehow?
Yeah, sure. I'm getting a couple of questions here, I guess to me, so let me read them. This goes back to consultant engineers. I want to say, in addition to LSRPs, I think, and I'll go back to the statute, but I think it's any license, even PEs would be exempt. But I'll go back to the statute and read it. But I think the intent there was when they were arguing the legislation that anybody that has a valid license, I guess they go to the LSRP, but Ps are in there too. They say that you would be exempt from having to apply for an A901. Again, because if you get a PE, and I assume, Phil, when you get an LSRP, is a code of conduct, right? So they're doing background checks. So, I mean, there's that redundancy that, the A901 is really just a criminal check. But if you have an LSRP or P, you've gone through that already.
Yeah, but having done the A901 in my career, it's very different than my LSRP code of conduct. And there's no background check on LSRPs. There's no fingerprinting. I mean, A901 is like going to the gastroenterologist. It's pretty close.
Can I ask a general question of the group? And I don't know everybody who's on this chat. Is there anybody from DEP or AG's office or the legislative aides on here that can chime in and help steer us?
I went through the list before. I didn't see anybody.
Okay, I just figured I'd ask just in case somebody decided to pop on. I know they were in, on your mailing list.
Yeah. We got 6 minutes left, and Tony, we talked a little about if you want to touch upon that this is going to take a grassroots effort.
Yes, it is.
And what we can ask of 102 people on this call to really be prepared to do.
Yeah, so I mean, here we are, April 5th. The legislature is in what's called the budget break, where they're listening to all the commissioners presenting their budget. So, they're back in the legislatures back in May and June, and then they typically take summers off, but that's subject to change. So our window of a legislative fix is really, I think, 2 months. And so what I'm going to ask everybody to do through the coalition is, and again, the senator is aware of it. We talked to the Speaker Coughlin about it. He's willing to help. We have to get the department on board. At the right point, we may ask everybody to maybe send an email, phone call to say, hey, this is a priority and this is important because, my company is worried about compliance, about keeping costs down, and doing the right thing. So we may ask everybody, just again, this is a priority issue, and there's a lot of things going on in Trenton right now that we may ask everybody to kind of weigh in, and please do so. Just say, hey, I'm a company and I do this, and this is important to me, and we really need this resolved. You know, but the window, I'm hoping that by the end of April, we at least have a game plan. And if we need the legislative fix, it happens in May, and we can get something through and the governor signs it by the end of June. Because again, the important point here is, you know, even if we get the legislature on our side and not the governor, he could always veto something. So that's why it's important to continue to work with the department. And they've been great. I mean, they understand what the issues are. They're just looking for, you know, ways to clarify it. But and I happen to agree, and this is something that I'll mention to the senators and the assembly people, that, you know, when they usually come out with a statute, you'll read like the second paragraph will be the DEP shall within 90 days issue rules. That's just never real. I mean, they can never issue rules within 90 days. Just the process is not set up that way. So, and this is a perfect example where by the time you get everything done, you're looking at a year out just to get it proposed. And then to get it finalized, it's what, another 6 months after that. So we wouldn't have final rules here for a year and a half. I mean, so I think it's a good look at the administrative process and what needs to be done. So going back to Philly, what you're saying is, yeah, look through either of our respective organizations that you belong to. You know, please rise up and weigh in, because if your voices are heard, then they'll say like, okay, let's pay attention to this and let's get some clarity.
And I know time is short now, but I wanted to go back to something because George had made a comment on the questions. Tracy, thanks for making your email available. Anybody who has questions for Tracy.
Yeah, I'm actually trying to look up Tony's, but Tony, what's your email? It's A Russo?
A Russo.
At CIANJ.org.
You know,
That in the box, and Jen's is,
Solewski, I can type my name.
all right, you put your own in, yeah, it's longer.
and you know, question 6, it talks to, you know, must a business concern register and subsequently apply for A901 under the dirty dirt if you only deal with clean soil or fill, and it goes into Jen's favorite non-restricted soil and fill recyclable materials. Is clean, I mean, this goes back to the whole thing of clean fill in New Jersey. You know, if it's not sampled, is it clean?
Yeah,
Sure, maybe.
maybe, I don't know.
If it comes from, you know, virgin, you know, land clearing, because there's so much of that in New Jersey, that, you know, that's unimpacted, and, you know, maybe it might be, you know, if it's a residential application and it's, you know, the pool contractor, or you're doing some yard work or whatever, and your contractor is, you know, trying to get rid of it for you. You know, and it's not related to a tank pull or anything like that. It's not coming from, you know, a leach field. I think that you're, you know, you can safely say that you could fall under this, the non-restricted soil and fill. But, you know, if
user beware.
Yes. user beware.
I have a chapter and verse of clean, I'm sorry, sources that were presumed to be clean that weren't now. DEP is reading the definition of clean fill as meeting all standards. They're saying that all standards means that there should be no averaging for clean fill, which is absurd.
well, they're not calling it clean. They're just calling it non-restricted. So they're
Yeah,
carefully
that's
not
what we have a
calling it
new
clean.
category with no definition.
Mhm. Oh, it's the same definition as soil and fill that's regulated, except this
Yeah.
is, you know,
Not
I don't-
regulated.
Not
It's regulated, but don't ask, don't tell, right?
right.
The 60 cubic yards
Prove
of Tony's backyard in Jackson for his Olympic-sized pool, I can use to fill my property.
Irrespective of it came from an orchard.
Yes.
Right.
Mhm.
Does he have naturally occurring arsenic? He's in freehold, maybe.
I don't know what that is, Jen, but thanks.
That's fine.
So there's a bunch of, you know, questions. I think I think this dialogue has to stay open. I do appreciate, you know, Tony, Jen, and Tracy have really pushed, you know, with DEP. There's been coalition calls with the senator, and I know, you know, CIANJs. If you're not a member, I'm going to plug them. You should be. There's a daily newsletter that goes out. and you basically know where you are and know what's happening in Trenton. And, Tony said it, and I'll repeat it again. This is going to take all of us to be able to get good clarity and possibly be able to get a good bill, a good rule out of the department in a year. So this is only the beginning. And, I'm not real confident it's a year from now that we still don't have rules, considering there's many rules that are still not out that we've heard would be out last year. There's a lot going on. Closing remarks, Tony, Jen, and Tracy?
Only closing remarks are just in case we don't get the relief, have a plan for your organization, how you're going to comply with it as is if things don't happen. So because the 901 application is not something you fill out in an hour. So maybe fill it out and don't do anything with it. Start collecting the data for it. Think about who's in charge of the specific tasks that are regulated and figure out how to take some of those tasks away from them if you want to keep your employees and not have their state police show up on their family's doorstep to do the interview. And that's my 2 cents for now.
Yeah. And there are workarounds. I mean, if you have material that you're taking anywhere, you can always get a bud, and then you'll be exempt because the department just basically needs to track the material that's not currently being tracked. So if you're going to a bud site, there's a reporting requirement. If you're going to an SRP site, there's a reporting requirement. Same with Class B, same with the landfills. So any material outside of that reporting is the intention of, they think that if they capture that portion of the dirt that's moving in New Jersey, that's when they're going to find, and I guess inhibit people from illegally dumping.
Or maybe you just adopt a corporate policy that even if it costs more, you're only using those 4 options for all your disposal needs.
And we didn't even touch upon the PRCRs about who handle their own soil. So that's another scenario, Tony?
Yeah, the last thing I would say, Phil, is all of you on this call are on the front line. You guys are out there in the field. If there are scenarios that you're concerned about or you question, shoot us an email so at least we can kind of catalog them. And then when the legislators, we can kind of show them examples and say, here's why it's created confusion, because this scenario was never thought of. So that really helps to give them some real live examples.
Yeah, and include all of us in the email because we talk to multiple different constituent groups.
And again, Phil, thank to you, George, Jules. I mean, you guys do a great job at CPES. These are very informative and I enjoy doing them. So thank you.
Thank you.
Good to share the panel with both of you.
Likewise.
Okay, everyone be safe, stay well, and fill out your registration.
Take care.
Okay.
Thanks, everyone.
Thanks.